consent searches, automobile searches, and inventory searches. So again, just review your search warrants. Remember, if we don't have a warrant, it's de facto unreasonable. We talked about how you file the application, how it has to be a neutral and detached decision maker, has to be stated with particularity, it can't be stale, and there's rules that guide the execution warrants, including knock and announce and use of force. So let's build upon this, right? Because we have 2 days dedicated to theoretically unreasonable searches, right? Because the Fourth Amendment has told us, and we've interpreted it, to protect us against unreasonable searches. And the Supreme Court has said, when you don't have a warrant, it's de facto unreasonable, right? So it is automatically unreasonable. Now, while warrantless searches are reasonable under certain circumstances, they are presumed initially to be unreasonable until sufficient cause has shown an exception, right? So when we talk about, you conduct a warrantless search of your home, you consent to it, we'll get into all that detail in a little bit. We go to court, that judge is going to say, this is an unreasonable search. That's on the prosecutor to prove that it was reasonable, right? To prove that, yes, they consented, or that there was one of these other exceptions to the warrant requirement, right? So theoretically, you go into court, judge is about to toss this case, prosecutor has to prove to the judge, look, it's a consent search, this person signed this document, blah, 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 blah. So, that being said, we recognize several exceptions to the warrant requirement, right? So again, we still have to prove it that we met the exception, but these are fairly well-known exceptions, right? So the first we'll talk about today is search incident to arrest. Right? So when you get arrested, where can police search? Where can they search around your person? Where can they search around you, etc.? Consent searches, these are where you agree to the search, which I'm going to tell you initially, I'm going to tell you again, never agree to a consent search. Never agree. Ever. Right? You might not have anything. Don't agree. The reason I say don't agree, even if you think you have nothing to hide, is one, they're going to tear your place apart, but two, there are dirty cops. Not saying all of them are dirty, not saying most of the police are dirty, but the fact is there are dirty cops. Right? You don't want something planted. If you don't consent, it can't be planted. So we'll get into that a little bit. We'll talk about automobile searches. So cars, we're going to see they have a different expectation of privacy in our car. And we'll talk about inventory searches. All right, in the next class, we'll move into inspections, regulatory inspections, and other kind of miscellaneous searches. So, search incident to arrest. All right, so when we arrest somebody, we can conduct a warrantless search of the suspect and his or her immediate area. All right. Now, this notion, right? Remember, to have a search, we have to have an expectation of privacy. All right. So let's say the guy is wearing, I don't know, clear pants. Well, maybe you don't have an expectation of privacy, right? Maybe it doesn't constitute a search. But theoretically, when you get arrested, right, you get patted down. That's a search. You have an expectation of privacy on your person. We can also look in the area around you. Right, and we say, look, we can look in the area around you, we can pat you down because the benefits of doing so outweigh the costs. Right, so your liberty is given up, or we've intruded upon your liberty, but we are doing it for the safety of the officer, prevent the suspect from resisting arrest, and to preserve the safety of evidence. All right, so the idea is we want to look in an area where maybe you could suddenly lunge to and grab a weapon, right? Look around, maybe you drop like your crack rock or something like that on the ground. We're going to search in that area. We're just going to look around, right? This obviously is a little different if you're being arrested in a house versus if you're being arrested outside. Right? Outside, around you, you don't really have any expectation of privacy. In your house, you have the heightened expectation of privacy, right? So we kind of see like a smaller area that you can search. And we'll get into detail when we talk about Chimel. That being said, a search incident to arrest must be contemporaneous to the arrest. And it must be contemporaneous to the arrest. Thought process behind here was to meet the contemporaneous requirement, a search incident to arrest may be conducted at the place of arrest or upon arrival at the place of detention, right? So we can pat you down, we'll arrest you, before we put you in the car, and then when we get to the jail where we're detaining you, then we can pat you down there again, or we can do that for the first time there. Those are really our first two things that we can do, right? For search incident to arrest. That being said, we have seen the police test how far we can go with search incident to arrest. Right, so there's a very good case, Preston versus the United States. It's a 1964 case, involves towing a car. All right, so does anybody want to talk about this case? I know about this case. It's nothing science. But you're kind of raising your hand. Let's go with you. You're right. So like police basically they do an arrest and they tow the car, right? Was the court cool with that or no? Let me try again. They were not, right? In this case, Preston, right? We're talking about the criminal justice revolution. They weren't cool with it, right? So again, the guy make an arrest, and then they have the car towed to the police station where they go through it, right? And that's where they find the evidence. Preston versus United States said, no, 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 no. No, 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 no. Right? That's not a search incident to arrest. Right? You weren't doing it for the safety of anyone. Right? That's the whole point of this, is to protect the evidence and protect the persons. You can't tow the vehicle unless it's an inventory search. We'll talk about that. You can't just tow the vehicle to somewhere and then go through it. Right? The idea, remember, our guiding principles, safety of the officer, safety of the evidence, kind of our big guiding principles. So court was not cool with it, said you can't just tow a vehicle and then go through and search it, right? It has to be back to this contemporaneous requirement, right? Because you've made the arrest, then you tow the vehicle, and then you search it. That's not contemporaneous, right? It's not at the same time. So that was shot down, but there will be an exception that comes that lets us do this. So before we get to our exceptions, let's talk about search incident arrest. Has to be reasonable to fulfill the Fourth Amendment, right? So again, we go with the reasonableness requirement, and we rely basically on the totality of the circumstances, but we look at every case and say, okay, the places that you searched around this person, was it reasonable? All right, so we have case that you had to submit today in hard copy and online, Chimel versus California. It's a 1969 case, so basically right after the Warren Court. Well, right in time with the Warren Court, I should say. Gives it away, but what happens in Chimel? Yes, ma'am. Hmm?
They would arrest him and ask to search the house, and he said no, but he said under law, like presumably lawful arrest or something.
Hmm?
He had to let them, and so they searched for like homes and things for like coins worth.
Yeah, absolutely.
Basically said that you can't do that because they didn't have a
Okay. Yeah, I think you hit the high points, right? So Chimmel basically gets arrested at home, right? Police come home, he's not there. Wife lets him in. But you gotta think, like, what's the wife thinking? Like, yeah, you're here to arrest him. Yeah, come on in, have some tea. Now sit down, relax. Like, maybe that was an unhappy marriage. I don't know. But suspected of robbery, right? Basically robbing a coin shop. He comes home. Police officers handcuff him in the living room. Right? Ask if they can search the house. He says no. So it's not a consent search. Officers say, oh, well, we can do it as a search incident to arrest. Right? So they arrest Chimmel, right? And they search what we now know as the permissible grounds is the immediate grabbable area. Right? So theoretically, anywhere somebody could lunge, right? Like a normal human being could lunge quickly, grab a gun, destroy evidence, whatever, just somewhere they can lunge. Now, Chimmel, didn't they bring him around to different rooms in the house? They knew this, right? They knew that they could only search the immediate grabbable area. So their thought process was, all right, we'll just drag him through the house, right? And then it will be search incident to arrest. And the Supreme Court goes, no, not cool, not gonna fly, right? We're talking immediate grabbable area. You can't move the suspect with the intent of like searching, right? It's only where you can grab, right? That's the whole point of this. Safety of the officers, safety of the evidence, right? Only somewhere you can grab, where you can grab their weapon, or you can grab a piece of evidence, destroy it, wherever it is. Now, to help understand this exception, right? Or at least the justifications for this exception to the rule, you have Arizona v. Grant, which deals with passenger compartment in the vehicle, and then you have Riley v. California, which deals with cell phones. So, somebody here tell me about Arizona v. Grant. Yes, sir, in the back.
So Grant was arrested by the Arizona State Police on an outstanding warrant. And after they arrested him, they went to search his vehicle, and they found a handgun and a bag of cocaine without a warrant or anything. And went to court, and Grant asked the judge to suppress the evidence found because the search, he claimed that the search had been conducted without a warrant in violation of the Fourth Amendment. And the court overturned the case and said that the police family search the vehicle if it is reasonable to believe that he might access the vehicle or that that vehicle contained evidence of what he arrested.
Absolutely, right? I think you hit the nail on the head. So they're talking about the passenger seat compartment. Where was Grant in relation to his vehicle? Say again? He was away from his car. Was he in the back of the police car? So what? It sounds like a question. Okay, there we go. All right, more confidence. I like it. Yeah. Guy was handcuffed in the back of a fucking police car. And they're like, oh, search incident to arrest. How the hell is he going to lunge to his car, right, or the passenger seat or whatever the car? How is he going to do that if he's away from his vehicle? He's not, right? That's what the Supreme Court starts to tell us. It's like, yeah, he's not, right? I can't recall if Grant, if he was actually handcuffed in the back or not. There is a case that deals with handcuffs in the back, but the idea here was, you know, could he grab something out of the passenger compartment? Yes, sir.
It said he was handcuffed.
He was handcuffed. Okay. So, you know, could he grab something out of the passenger seat? Probably not. No. Right? Generally speaking, you're going to have to be in the vicinity. We'll talk about what that means in a second. What about Riley versus California? Right? This deals with a search of a cell phone. Yes, sir.
So
Riley was pulled over because he had expired tags on his car. And when they started checking his license, they realized he was suspended. So they, I can remember, yeah, sorry. He had a suspended license, so they arrested him, impounded the car, and then they took his cell phone that he had on his person, handed it over to a gang detective because he had a lot of gang paraphernalia in his car. And they went into the phone, started searching through the text messages, and found evidence of gang involvement, guns, drugs, etc., etc. The Supreme Court did not allow this because they said the modern day cell phone has an expectation of privacy because it contains a person's life on it.
Right, absolutely. So the idea was there was an expectation of privacy here, right? And that's probably unquestionable, right? This is 2014. 2014 is when we still had locks on our phones. Now we do like facial recognition or thumbprint or whatever you have to recognize yourself on your cell phone, right? So we set those locks for a reason, right? Only we want to access what's in our phone, right? We don't want somebody else to access what's in our phone. So we have the expectation of privacy, right? Now, was this a search incident to arrest? Was it? Yeah.
The search that uncovered the phone wasn't arrest.
So uncovering the phone is an incident to arrest, right? But was searching the actual phone incident to arrest? No, right? And partly because we have a vehicle involved. So vehicles we're going to look at, you only need reasonable suspicion to search a vehicle. But because we have such an expectation of privacy in our phones, they didn't do it incident to arrest. And they probably couldn't do it incident to arrest because what we've seen as case law says, if they want to search your cell phone and you don't consent to it, they have to get a warrant, right? So they searched his car, got the phone, they could take the phone, absolutely. But before they could go through the phone, they had to get a warrant, right? So that's kind of where we see, remember, the justification behind this exception, right, is we didn't want him being able to grab the phone and do like a mass delete or something like that, right? We didn't want him to grab a weapon. We could do the search. But once the cell phone is in the police's possession, can that suspect then do anything to hurt the evidence? If they're handcuffed, yeah, probably not, right? Probably not. So that kind of gives us an idea of, generally speaking, you cannot conduct a search of an area after an arrest is of the person if the search area is, quote, out of reach. So this gives us an interesting idea. What it basically allows us to do, right? When police have kind of figured out, is you've ever seen somebody on the side of the road, like they're pulled over and they're leaning on the back of, or leaning on the roof of the police car, right? Or the hood of the police car, leaning against the bumper, because police have told them to be there. They're keeping them there for a reason. Because theoretically, while they're in that area, they could grab something out of their car, right? And smart police officers will have you put your hands on the roof of the vehicle. Well, if your hands are on the roof of the vehicle, guess what? They're going through your car, right? They probably can't get to the trunk because it seems unreasonable that you could like dodge, open the hood or open the latch, run around to the trunk, dive into the trunk, whatever. But they can search the passenger compartment easily, right? Because your hands are there. You're on top of it. And have you leave your hands there while they search? That's what smart police officers do. It's shitty, but it's what happens, right? But as soon as we kind of get back past the bumper of the car, as soon as we put on handcuffs, then the reasonableness question changes, right? If you're handcuffed, I don't know if any of you have ever been handcuffed, like it's not pleasant, right? Your hands are basically like this behind your back. The chain on most police handcuffs are very small, not like kind of commercial ones that you can buy. They also, a lot of departments are now using two other forms of handcuffs. One form of handcuff is the hinged handcuff. So it's basically the two cuffs with a hinge in the middle. So it keeps your hands even more locked into place. Other departments are using zip ties, right? Zip tie you into place. Kind of the more restrained you are, that's kind of getting more and more restrained, the less reasonable it is that you're going to be able to somehow get out of it, like open the lock from the outside police car door, go out, get into your car, get a weapon, go after the police. Right? So again, this is all about the theory of protecting the evidence, protecting the officers. Now, that being said, when we conduct a search incident to arrest, it does not matter, if the underlying thing that you're arresting the person for is a felony or misdemeanor. So let's say that they're pulling you over because you engaged in jaywalking. Jaywalking is usually a civil offense, but let's say it's criminal in this town. It's a misdemeanor, right? You get in your car, like it's on the side of the road. Police come up real quick, flip on their lights, get you out of your car, and arrest you for jaywalking. They can search your vehicle, right? As long as you're not handcuffed in the back of theirs. Theoretically, they can go through your vehicle. They can pat you down, right? Anything they find on you, they pat you down, they find a crack pipe. Guess what? That's fine, right? So the theory is we're going to search people regardless of the underlying crime, because people can be dangerous, right? It's a scary situation. Even if you go away for a misdemeanor, it's scary, right? And you're going to want to get rid of the evidence, or you're going to want to maybe grab a weapon, just instinctually, whatever. So we want to be as protective as possible for felonies and misdemeanors, right? That being said, a couple of things to note before we talk about citations. If you get arrested or if you get patted down, and the person who is arresting you is not your same gender, or you don't feel comfortable with that person's gender touching you, patting you down, you have an absolute right to have an officer of your gender pat you down. Right? So if you're a female, generally speaking, you can request, and that's where it really comes up the most, right? So if you're female, you can request a female officer. Now, that will eat up a lot of time probably, right? Because you'll probably have to get an officer maybe from a different area to come over, do it, whatever. And like, officers are going to be happy about it. But think about what they search, where the hands go, right? If they pat you down, usually it's palms down. Some jurisdictions now require palms up, right? So it's just the back of their hand. But they're going to go down, starting basically at your neck, go down. If you're a woman, they'll check the brassiere under the breasts. They go down, check the pockets, come back up, check the groin, and go from there. Men, they're just going to go down the sides, come up, check the groin, and go from there. So it obviously is invasive, but you do have the right to say, hey, I don't feel comfortable with this officer doing it. Can I get an officer of X gender, right? Whatever you want. Again, and that, I should say, the Supreme Court has basically said that as far as sex goes, not necessarily gender, right? Gender is more of an identity, sex is biologically assigned, right? So they say basically sex, but we can never leading towards gender, right? So if you're transgendered, you can generally request somebody of the same biological sex that you were born with, right? Courts are becoming more lenient, basically saying like, okay, you can request a guy, a girl, whomever. That's up to you. It's easier for probably everyone if you just like go, yeah, search, go for it. Not, let me look at this one. there are some police officers who will enjoy the experience, right? And we've seen sexual assault cases come from this. Right, so police officers, they spend like, if they're do more than just under brassiere, like they start to grope or something, or when they go to the groin, they start to grope. If you're male or female, don't matter. That's sexual assault, right? So if you're getting searched, best thing for you to do, especially if you have nothing on you, is to make sure it's done in front of the police car camera, right? Because it's amazing, or in your dashboard camera. It's amazing how police officers' attitudes change when they know they're on camera. Suddenly it's by the book, right? Because they know if they mess up any one thing, you're going to have all that evidence and you're going to either sue or try to get evidence thrown out, whatever. That being said, we are seeing more and more departments starting to use the back of their hands, right? Traditionally, it's the palms, right? You have more sensation in your palms, right? You can tell it's like, oh, it's a phone, okay, right? It's flat. What's that? Those are keys. Okay. All right, you can grab them. A lot of departments now are starting to do this, the edges, right? Problem with the edges is, I know there's something hard in my pocket, can't figure out what the hell it is, right? It's more difficult to sense. When I was in Australia, so our airports, like if you haven't traveled internationally, well, depending on where you go, like China's crazy strict on airports, stricter than us. Like I almost got arrested from coming back from Australia in Hong Kong. Because I bought like a didgeridoo. You know what a didgeridoo is? It's basically like a wooden band. It's like a bamboo half pipe, and it's an Aboriginal musical instrument. You kind of buzz your lips into it, and it almost sounds like a vuvuzela, right? So, like I was waiting at the Perth airport because, like they thought this one person wasn't going to come, and this one person was sitting in business class. I was the first one there, and then I said, "Oh yeah, I'll give up my seat. Yeah, I'll take it." They're like, "Okay, well, just go upstairs." They give me like coupons to go eat food, and I go upstairs, and if they don't show up, we'll announce you, and you can just come down and get your business class ticket and go, which is great because I was flying to Hong Kong, and that's like an 8-hour flight. If you ever have to fly more than like 2 hours, go business class. Yes, it costs thousands of dollars. For me, it was free. It cost thousands of dollars, but it's worth it because my flight from Hong Kong to the United States was more on the 18-hour mark. So, and I was in coach right next to the laboratory. Yay. But Australia, so they don't have the scanners or anything like that. They have a metal detector, and their extra search of you, like if you get randomly called out for a search, and I did, was they used the back of their hands. And this is what they did. They seriously went, "All right, you're good." Like that's the, oh, okay. If that makes you happy, that makes you happy. Right? Because I went up there and I was like, I took out my laptop, I was taking out my shoes, and the security guard goes to me and he goes, "Oh, you must be American made." And I was like, "Yeah, how'd you know?" He goes, "You don't do that here." I was like, "Oh." So like, you wear your shoes, wear your coat, like they didn't care. But I get to Hong Kong and I go through their customs portion, like their search portion, right before I boarded a Chinese airline. And they almost arrested me for the vuvuzela, or excuse me, the didgeridoo, because they thought it was a weapon. Like, and I got searched twice. Once when I was going through, and then once when I was getting on the plane. Both times they had to call supervisors to make sure that I could bring my didgeridoo on the plane, that it wasn't going to be like a metal pipe that I could beat somebody with. And I was like I had to demonstrate it was a musical instrument. So like I had to play the didgeridoo in Hong Kong. And they were like, "Oh, it's really pretty," because like it's decorated by Aboriginal, like it's an Aboriginal crafted piece. It was just like night and day. Go from Australia where they legitimately do not give a shit what you do, right? To go to Hong Kong where they're like even stricter than the United States. But again, other jurisdictions, other countries use the back of their hands. And the idea is generally speaking, if you use the back of your hands, you're gonna be able to tell the difference between a cell phone and a gun. right? So one's a flat, square. Again, for the most part, they're going to have like pokey parts, like you're able to see. That's the thought process behind that. So back to our slides here. Doesn't matter if it's a felony, doesn't matter if it's a misdemeanor. What you do is search incident to arrest. However, if it's a citation, it's an exception to the exception, right? Search incident to arrest is an exception to the warrant requirement. If you pull somebody over for a citation, it's an exception to the exception, right? Meaning you have to get a warrant if you're doing it as a citation, right? So we have Knowles versus Iowa. This is a citation for speeding. Did a search incident to arrest. Found some stuff. They let the person go, right? Just gave them the ticket to go. That's all they could do. It was just speeding, right? It wasn't a misdemeanor. It's a civil infraction. Unless you're going like over a certain, if you're going 20 over, you're in the misdemeanor to felony category. But if you're just going like 5 over, it's citation, it's a civil thing, it's not a criminal thing that you have to report. So, give them a citation, right? They went all the way to the Supreme Court with this because they found a lot of like drugs. Go all the way to the Supreme Court. Supreme Court says, no, like that's not, no. Why would you get somebody out of their car? If you pull somebody for speeding, why would you get somebody out of their car, right? Have them put their hands up on the dash or whatever and search around. Like, it doesn't make any sense, right? That's a violation. So you're not talking criminal infraction, you're talking a civil infraction, right? That's a huge violation of your expectation of privacy. That being said, there's a caveat that comes from this. If the situation allows the officer a choice, right, to give somebody a citation, which a citation is basically just a court summons, right? Basically, you're technically arrested and like you get the court summons and that's it. Or if the statute allows for the officer to make an arrest, then we can do a search incident to arrest, right? But only if the officer elects the arrest portion, right? So if they just say, oh, yeah, I could either give you a ticket or I could actually take you to jail for this. And they say, but you know what, I'm gonna give you a ticket. They can't search your vehicle, right? It's not search incident to arrest. If they say, you know what, I can give you a ticket or I can arrest you for this, I'm gonna pull you out of your vehicle, come on, making the arrest. Then they can do a search incident to arrest. That's if the officer gets to choose. Now, you can see where this is headed, right? If now officers get to choose whether they give you a ticket or they arrest you, it creates an incentive, right, for police basically to find an offense where they can either give you a ticket or arrest you, right? This often results in what's called pretext stops. Right? So pretext stops, trying to think how to best describe them. It's when the officers think you're doing something else, like they think they're after you because you have drugs, or they think you're drunk driving, something along those lines, and they pull you over for not using a turn signal, or they pull you over for a light being out on your plate, right? Something minor. And the idea is they stop you, theoretically, they don't care about the plate, they don't care about the turn signal. They think there's something else going on in that car, and they want to get access to you. That's a pretext stop, right? And so we see Wren versus United States basically tells us, okay, pretext stops, like the fact that we're after you for some other reason, but we pull you over, it's perfectly fine. It's perfectly legal, right? Because theoretically, you did break the law, right? So they can pull you over. You didn't use your turn signal, you broke the law. Regardless of what they had in their heart, you broke the law. That was interesting because you have Justice Scalia arguing one side of this, and I believe it's Justice Ginsburg was in the minority, and Justice Ginsburg said, well, this doesn't make any sense, right? When you're driving, basically, you're going to break the law at some point, no matter what, while you're driving, right? So if we can just follow you around, especially if the cop is following you, suddenly, like, you look in your back mirror, suddenly your hands go to 10 and 2, right? You're very, like, cautious. You go 1, 2, 3, 1, 2, 3, 1, 2, 3, then go, like you're extra cautious. But it creates that nerve, right? And when you do have that nerve, you might forget to do something. Or especially if it's old habit, like you're turning off the street to your driveway, you're supposed to use a turn signal. A lot of people, if they're just turning off the street to the driveway, they just turn, right? Like, especially if it's like a private drive, or not private drive, but like a short drive, like off the main strip, right? Just a private little, small little road. Not gonna use your turn signal. But it's technically breaking the law, right? And that's what the court says is like as long as you're breaking the law, they can pull you over for whatever the hell reason they want to, right? Because you broke the law. Now, once they get up to the vehicle, let's say they smell marijuana, and they're like, they come up, you know why I pulled you over? Also, that's a trick question. Never answer that question, ever, right? But they come up and they'll say, you know why I pulled you over? And we'll say you're drunk, they can smell it on your breath. Well, suddenly, all right, we have an arrestable offense, right? Or they smell marijuana. Or in a state that doesn't allow marijuana usage. That's an arrestable offense. Some states, Massachusetts being one of them, well, it used to be, it changed. Massachusetts was like they decriminalized marijuana. So basically the officers found it, they could do one of two things. They could give you a ticket, or they could arrest you. But the incentive was to give you a ticket. Because if you make an arrest, you have to do this really long police report, like a really long narrative. And just for pot, like, not a big deal. If you ever walk through the Boston Commons, you will get a contact time. Like, people are just on the benches smoking pot. Like, they don't give a fuck. If the cop walks past, they don't try to hide it. They're just like, because they know the cop's not going to do anything. But let's say they pull you over at night, and they think that you're actually like this gang member, right? They pull over, and you know I pulled you over? Your tail light was it. What's that I smell? It smells like marijuana. Well, when they smell it, it's a plain smell, just like plain view. They can pull you out, search your vehicle. All right, we'll talk about reasonable suspicion in a little bit and what that entails. So we know that pretext stops completely lawful. Now, I'll say this again when we talk about interrogations and confessions. Never, ever, 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 ever consent to a search, and never, ever, 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 ever answer the officer's question, do you know why I pulled you over? Because let's say you're wrong about why he pulled you over. You just told him something else. Like, oh, by the way, this is also wrong too. He might have just pulled you over because you had one tail or a tail light out. Was just going to tell you about it, right? Because if you have like a light out, usually the cop just tells you about it and lets you go. Because you don't see the back of your car. How do you know? Most cops are friendly like that, and they'll do that. But if a cop comes up and says, you know, I pulled you over. Yeah, I have an outstanding warrant. I know. Cops like, what? Right? Suddenly, like you got from just, hey, just wanted to let you know your tail lights out. They don't even run your license or anything like that. And just letting you know, have a good night, to hand on gun, get out of the vehicle. Right? So you can be wrong. One, even if it's not like you have an outstanding warrant, but you were speeding, your odometer says one thing, the police speed gun says something different most of the time, right? So if some cop comes up and says, you know, I pulled you over, you said, yeah, it's because I was speeding. Cops immediately ask, you know, how fast you were going? You might say, yep, I was doing 20 over. You literally just confessed to going 20 miles over the speed limit. The cop's gun has you at going 5 over speed limit. Difference in fines between $5 or 5 over and like 10 or 20 over, massive difference, massive difference. But instead of writing you the 5 over, You just confessed to going 20 over, right? And if you tell the cop, like, oh yeah, I was speeding, but you're like, oh, I don't know if I was going, you still admitted to speeding. So you can't get it shot down in court. If you don't tell the cop, you're like, if you play stupid and don't admit anything, most of the time you can get it shot, at least tickets taken care of in court. Because you say, because the officer has to show up, right? And you have to ask some questions. When was the last time your radar gun was calibrated? Do you give me service dates of your gun? Well, then how do we know if it hasn't been calibrated in a year? How do we know it's accurate, right? And again, it's enough to get it thrown out. Also, your Miranda rights apply when you get or at the stop. So, like you've directed remain silent, and we'll get into that when we get into different sections. So, questions about search incident to arrest or pretext stops, the underlying offense, anything along those lines. All right. So, consent searches. This is where I'm going to say it again. Never, ever, ever consent to a consent search. Never say, if an officer asks if they can search somewhere or search you, search their car, whatever, if they're asking you and not telling you, it means they don't have probable cause to do the search. Right? They don't have probable cause. They're asking. If they're telling, they don't have probable cause, well, they'll get thrown out. But if they're telling you, like, that's a whole different scenario. You're never going to, like, talk your way out of trouble with these officers. Talk about this when we talk about confessions. You'll never be able to talk your way out of trouble. And the fact that you let them search your car or search your home, they didn't find anything, it's not going to be like, oh, okay, we don't have to worry about this person anymore. Like, no. They're going to find something, right? Like, different types of knives are illegal in New York. Some people like to play a game on Amazon of will it ship, right? So some people will go on and buy the most ridiculous, like, knives, switchblades, whatever have you, just to see if it'll ship. Theoretically, a cop comes in and wants to do a consent search. Maybe they think you have drugs, but they're looking around. You consented, and they see your stockpile of weapons that you'll never use because you're bored and you like to play games. You're getting charged with all those, right? So just kind of keep that in the back of your mind. Don't ever agree to a search because you don't know exactly what's legal and illegal. And again, police do plant things. We know this. Not every time, not most of the time, but sometimes they do, right? So if we're talking consent searches, police do not have to have a legal basis to do a consent search, right? So they can literally just randomly go up to doors, knock on the door, have no reason to search it, and say, can I search your house? That's perfectly legal. So is telling them, fuck off. Like, that's perfectly legal. Right? Again, if they're asking, it means they don't have probable cause. If they have probable cause, they're not going to ask. Right? There are things called knock and talks. And generally speaking, these are almost always permissible. Knock and talk is police officer knocks on your door and starts engaging you in conversation, right? Something along the lines of, hi, I'm investigating drugs in the area, and I heard that you might have some. Like, you're standing outside their house, they're standing inside their house. That's fine, that you haven't broken the threshold, right? As soon as you break the threshold, then you've entered the house illegally, right? So knock and talks usually allowed. Knock and talks also include knocking on the door saying, hey, can I search your house? Almost always permissible. Now, that brings us to our test for voluntariness, right? So if the police say to the judge goes, there's no warrant for this search. It's de facto unreasonable. Mr. Prosecutor, tell me why I shouldn't throw this out. And the prosecutor goes, it was a consent search. Judge is going to say, prove it. How are they going to prove a consent search? They're going to use this lovely test. Who wants to try and pronounce this one? Schneckloff v. Butzamonte. That's about as close as I can get. This is why I don't say your all's names, because like I would butcher them. But we use Schneckloff test. The Schneckloff test for voluntariness basically has, well, you're going to see the totality circumstances pop up, but it has to have no duress or coercion, right? So the person can't feel like their back is against a wall, right? Like they have to do this. You can't say, if you don't let me search your house, I'm going to get a warrant, then I'm going to come search your house. They say that, you go, fucking good, go, right? Like, fuck off. If you can get a warrant, why are you asking? It's not going to help your case. It's not like the cop's going to be like, oh yeah, it was really good. He handed all over his drugs, and then yeah, this was really great. And the judge is going to be like, oh, he's a nice guy, let him go. No, that doesn't happen. So you can't have express or implied coercion, right? You can't feel like I have to do this, or something's going to happen to me, or they're going to get a warrant and they're going to come back and it's going to make it worse, right? Police officer says, if I find drugs in your apartment and you let me search now, I'll only charge you with a misdemeanor. If I have to get a warrant, I'm charging you with a felony. There's one problem there. Police don't decide what they charge you with, what you get charged with. It's the prosecutor who decides what you get charged with. So they can lie to you, right? And that's where we start to walk a fine line of, was that duress? Was that coercion? Do you say, well, oh, it'll only be a misdemeanor? Yeah, you can search, that's fine. We're probably going to say that, I would argue that's coercion, right? Forcing your hand, basically doing something to force your hand. This test for reasonableness is basically, was this voluntary under, here we go, the totality of the circumstances? So based on the whole picture, was there duress, was there coercion, right? So let's say police knew before they knocked on your door to ask you if they could search that you have an anxiety disorder. They knew. Do we have duress or coercion? Was it voluntary, right? And how we get to this answer is we put the person on the stand. We have a hearing to decide whether we're going to allow the evidence in. So we put the person with the had anxiety disorder on the stand and say, when the police approached you, how'd you feel? I was really anxious. I started to have a panic attack. All right. How did you show any signs of having a panic attack? Did you say something about having a panic attack? Yeah, I bent over, I started breathing really hard, and I started shaking, and I just said yes. Okay, that's going to feel like coercion, right? As opposed to, yeah, I have anxiety disorder, but I took my pills that day, didn't even think that I had a nuclear weapon in the basement, and just said, yeah, come on in. Right? That's going to be a big, big difference. So again, this is similar to the probable cause determination. Prosecution bears the burden once challenged by the defense. Right, so the defense will always say, you didn't have a warrant. And then the prosecution has to go through this whole process of proving it. And no one single factor has to be determinative. It can be determinative. But we know that some factors include overcoming the will. Right? So police can use a little coercion. Police can use a little duress. But it can't be enough that it overcomes your will. Right? Because it forces your hand to do something. Right, so they can say, if we say the example of, can I search your house? No. Well, I'll be back with a warrant. That's coercion. Is that enough to overcome your will? It depends, right? Totality of circumstances, case-by-case basis. You have mental problems, you have some mental health issues, that changes the analysis. If you're intoxicated, that changes the analysis. Right, so we look at every factor and say, did it overcome this person's will? Right, was it voluntary based upon everything we knew or should have known at the time? Right? So, looking at other voluntariness factors, right? So the use of coercive police procedures. Excuse the typo on the slide. So one thing we look at in determining will is the police to suspect ratio. So let's say it's one single cop comes up, knocks on your door, says, "Can I search your house?" Okay, it's probably not going to be coercive, right? If they just say it like that. Good? Because then you can say literally, "Fuck off," and they have to fuck off. Yeah, right? But let's say police knock on your door, and there's 15 of those fuckers standing out there. They say, "Can we search your house?" That changes the analysis quite a bit, right? Especially if those 15 officers standing on your lawn, the representative that knocked on the door says, "All right, we'll be back with a warrant." And you go, "Okay, no, just come on in." Right? Like, you think, okay, they have enough to get a warrant, right? Look at how many there are. Right? So we look at the police to suspect ratio, right? And honestly, if it's more than like 2 to 1, then we really start to question it. Right? You have like 3 officers, and you'll see people get pulled over on the highway, and there'll be like 19 cars behind them. Like if they get pulled over for speeding, that's coercive, right? So one time in Massachusetts, if you ever need to rent a car, like and drive it locally, don't rent it from like Enterprise or something like that. Get a truck from U-Haul. Like they have pickups at U-Haul. Like you don't have to haul shit. You can just rent the truck. It's like $20 for a day. Like your basic rental car is gonna cost you $40 at least, plus all the insurance and stuff like that. So I was in a U-Haul truck, like a pickup truck, like I was in the shop, and I'm driving back from the train station at night. My headlights are on and everything else, and I pass a New York State police car. I see my rear view mirror, he does a U-turn. I'm like, fuck me, right? And then, like, I just pull over, because I'm like, he did a U-turn, like, I know what's gonna happen. So I just pulled over, he pulls over behind me, flips on his lights. He gets out, he's like, "Hey, how you doing tonight?" He was a really friendly officer, right? Really nice guy. You know, so there's a trick that you can use. If you ever get pulled over, put your hands outside the window, palms out, always, right? Because that tells the police officer you're not armed, you're not a threat, right? You're trying to cooperate, and it's gonna put them in a better mood, right? The officer actually came, I had my arms out, he came up, he thanked me for it, right? And he said, "Yeah, just so you know, your brake lights, they're not working." I was like, "Oh, I'm sorry." And he goes, "Yeah." He goes, "Oh, I just saw this as a U-Haul." I was like, "Do you want to see my rental contract?" He's like, "Don't worry about it." He goes, "What you should do is," and then he stopped because another police car had come up behind him. Another officer had gotten out, right? And he goes, "Oh, just 1 second." So he goes back, talks to the other officer, and he goes, "Hey, sorry about that. He was just telling me a story." I was like, I'm sitting there shaking because I'm like, "Oh, fuck. Like, why is there 2? Oh, he's telling me a story." I just want to be like, "Fucker." But no, I restrained myself, and I was like, "Oh," I'm like, "Oh, okay, that's fine." He goes, "Yeah, well, I meant to tell you," I said, "Call U-Haul, tell them about the problem. But as you're driving back home, just if you see a car behind you, just tap your brakes. Just because if you tap them, they work, but they're just not on, right?" And he said, "And if anybody pulls you over between here and there, here's my card." And he gave me his business card so that I could say, "Hey, officer pulled me over, told me to do this. I've already been pulled over for it." Right? They could still give you a ticket, but they're not going to. Right? So again, how you treat the officers is a lot of times how you get treated, but there are some that are just complete dicks. This guy was he was like the overly nicest police officer I've ever met. But again, when 2 cars pulled up, then I started to get real nervous. The 3rd car pulled up, I'm like, I'm fucked. I'm going away for murder or something, like, I don't know. So police to suspect ratio is really important. Psychological pressure, right? So this is, we know you have like a mental issue, or we start saying things that kind of break you down emotionally. The things I like to say to my students, if you're pre-law, just know that when you get and join the pre-law club, you will get berated and harassed and in a loving manner, right? We have a group chat. There's an alumni group chat. people who know Elizabeth Foster, like, I like to break her down emotionally because she's in law school right now, and like, super easy to break down. If police play that game with you, that's coercion, right? Again, threats to obtain a warrant could be coercion. False claims of a warrant, absolutely coercion, right? The police knock on your door and say, "Can I search?" And you say no, and they say, "Oh, I have a warrant." You block that door and say, "Show me," because they have to produce the warrant, right? And if they ask to search your house, they don't have a warrant. Like, they don't bring out the SWAT team to ask a favor. They bring them out to knock down the door, secure the place, and then go through it, right? So, again, always ask for it. If they give you a warrant and it's fake, anything they find in that house is getting suppressed. Right? If you get a warrant and it's real, well, they have a warrant, so you're screwed. Right? Number of requirements. Wow. Number of requests made. Right? So how many times have they asked you? Did they come by 4 times in a day and ask to search your house? Like, does it feel like it gets to the point of harassment? Yeah, they come up to your door, come out. "Hi, Ms. Johnson. My name is Officer so-and-so. Can we search your apartment?" "No." "Okay, thank you." 2 hours later. "Hi, Ms. Johnson. It's Officer so-and-so again. Can we search your apartment now?" And they keep doing it. All right, the more times they ask, and it doesn't have to be separate transactions. They can have a conversation with you and ask several times. But the more they ask, the more likely it is you're going to break down and just be like, "Search. I don't care." Right? Fine, just go with it. We're going to look at where were you in custody at the time of the consent. This one is almost like a dead kill of consent, right? So let's say they arrest you for something that you did like outside. They don't have any evidence to believe there's anything in your house. They don't have a warrant for your house. They arrest you on your front stoop, right? So they put you in handcuffs and put you in the back of a police car. They let you sit there for a few minutes. Officer comes back and goes, "Can we search your house?" And you say, "Yeah." Because you're probably terrified. Like, you're probably peeing the seat at this point. Right? So you're going to try to cooperate and try to make the officer as happy as possible. You say yes. We're going to say that's probably going to overcome your will, right? Overcome your will to resist. Like, you're in the back of a cop car, handcuffed. There are lots of officers there. I mean, again, no one factor is determinative, but we're going to look at it, everything as a whole. But custody is a really big one, right? Because if they've restrained your right to movement, right? So you have to have a problem there. Also, we look at, were you aware that you had the right to refuse? Now, that being said, the Supreme Court has said out of all of these rights, right, and they say no one is determinative. If you're aware of your right to refuse, that's a tiny factor. Almost doesn't matter. Let's say you didn't take this class, you didn't know you had the right to refuse somebody, police officer coming to search your house. You say yes, they search your house, and then you get to court and you go, "Well, I didn't know I could say no." Judge is going to say, "Well, looks at everything else and goes, I don't see anything that's coercive here." You let them do it, right? Because you're expected to know the law and your rights at all times. Now, that being said, some of you and some of my clients got into trouble when they thought that if they appeased the police officer, the officer wouldn't do it, right? So one client that got pulled over, he had heroin in the back of his car, I think. They have him out of the car, they issue an exit order, he goes back, stands by the car, say the police car, and they say, "Can we search your vehicle?" He knows he has heroin in the back of his car. He says, "Yeah, absolutely, go ahead." When I meet this client, the first question out of my mouth was, "Why the fuck did you say yes?" His answer, and actually I had a couple other clients answer the same way. They said, well, I thought if I said yes, they would think I have nothing to hide and they wouldn't search. And I'm like, if you say yes, that's like giving the keys of a toy store to a child. Like, they're gonna go bananas. Like, they're gonna search. Just gonna happen. It's not that they're gonna take your word for it that there's nothing there. Like, go, oh yeah, you have nothing to hide. Okay, you know, despite the fact I pulled you over, whatever. You have nothing to hide. Like, okay, that's fine, that's cool. No, never in the history of ever. I've never heard of an incident where somebody asked to search, and the person said yes, and the officers didn't search. Right? I've never heard of that. So again, you have to stand for your rights. You have to know that you can say no. Don't think you're going to outsmart the cop or use psychological tricks, because they're trained. They're trained in such a way that, like, you get consent, you search, right? Like, you just do it. Because there's something telling you something's wrong, right? And you want to make sure that people are safe, you're safe, etc. So these are the factors we look at. Again, we look at the whole process, see if it's coercive. We also look at written consent, right? So written consent comes into play a lot more now. More and more departments are using this. Right? Because even though your awareness of your right to refuse is not that big of a deal, a lot of police departments now use a form. And I'll find the form and I'll post it on Canvas for you, but it's a form. And it says consent searches at the top. They have to put their name, the date, stuff like that. It has in big bold letters, you may refuse the search or stop the search at any time. And you have to write your name, sign your name, and date it. Right? And they give it to the prosecutor uses that to prove that it was okay to not have a warrant. The thought process behind it is, it's one thing to say, yeah, search my house. It's another thing to say, have like a couple of seconds of a breather, and then to put it in writing, right? We as humans, when we put stuff in writing, it kind of changes how we feel about something. Okay? It's really easy to say yes, but if you get a form, like, well, you have to fill this out before we can search. You're probably going to read that form over. Like, you know, when you have like Apple updates, you never read the damn contract. Like, I've never read it, lawyer, and I've never read the stupid thing. Like, I know what's in it, but never read it. This is one situation that you're probably going to read what it says, right? Read what it says, and it says, you can say no. And then it has your signature, like a signature line. That takes a lot of work to write your name, signature, date it, with you have the right to say no written right across it, right? And we use that because maybe the factors, maybe we had 15 officers, we asked 90 times, whatever, but we tell you in bold letters, you have the right to refuse. That's going to cure a lot of problems, right? Because under the totality of circumstances, judge is going to look at the defendant and go, it literally said you could say no. Well, and they come up with some bullshit excuse. That cures a lot of factors. Not all of them, right? Not determinative, but we use it to help in the process. The Miranda warnings. This one is an iffy one, because this one goes both ways, right? It goes towards duress, but it also goes towards informed consent. Right? So if a police officer comes up to you, reads you your Miranda rights, on one end of the spectrum, they're telling you what your rights are. The right to remain silent, right to an attorney. Then you go down the list. So suddenly you go, okay, I have the right to an attorney. I can request one before they can search. And you can. But the problem is, here's what gets officers caught up sometimes, is if they read you your Miranda rights, you have to presume that you are in custody. Right, once the Miranda rights get read, you're not free to leave. Usually they're cuffing you while reading you said Miranda rights. Let's say they don't cuff you, they just put you back in the police car, they read you your Miranda rights. You can say, well, I was in custody. And we know from our analysis earlier, custody is a really big issue. Even if they don't put you in the police car, they just come up, read you your rights, and then go inside your house, because you said, yeah, you're not free to leave. Like, you're being watched, you're not free to leave. that triggers something in you. Like, oh, I've been arrested, I'm in custody. We know custody is a really big factor in terms of like psychologically overcoming the will. Location of contraband. So this one's really an interesting one. Courts look at this and say, all right, you found drugs, right? Okay. And they consented to a search. But we're saying, no, their will is overcome. Judge, prosecutor, defense attorney, we're all going to look and say, where did you find the drugs in the house? Because if the drugs are on a very nice, neat pile on your coffee table out in the open in the middle of the living room, we think it's less likely that you said yes than if your drugs were hidden under a floorboard, right? Because the idea is like, it's out in the open, they're going to find it. Why the hell would you say yes? If it's under a floorboard, you're probably thinking, they're not going to get it. Right? I can get away with it. Which, again, the student in Alabama I had, who was the member of the drug cartel, the lieutenant of the drug cartel, when they searched his house, like he went to really crazy lengths to hide the drugs. Like he had a hole in his wall that he plastered over. Like every time he put drugs in it or take it out, like he'd knock the hole out. And like the police didn't like knock on the walls or anything like that. Like he goes to me and goes, I have a bunch of drugs in my house. He's like, my wall is filled with drugs. It's like, I just checked, they didn't get it. What should I do? And I was like, well, you have two options. One, you could call the police and be like, hey, you forgot something. Or option two, you could flush the fucking drugs. Like, what do you think you should do in this situation? Help me to help you, right? Like, common sense, flush the drugs. Also, don't tell me, because I'm a witness now. Just, But he got everything, he's doing well. Let's see. Consent has to be unequivocal and specific, right? So we'll talk about this when we talk about Miranda rights. If you request a lawyer, you have to be specific and say, I want a lawyer. If you say, I think I want a lawyer, that doesn't count. You have to be very specific. Here, you also have to be very specific. You have to give a verbal yes, or written yes, maybe you can't speak, whatever. You have to give some affirmation besides a nod or a gesture. Right? Because maybe you did like one of those things, like your neck, like, you know, I pop my neck all the time. And like you're standing by the car and he goes, can I search your car? And you go, okay, well that seems like a yeah. And you're like, no. If it's just a nod, we're probably going to say you didn't give consent. Right? It has to be unequivocal and specific. Yes, you can. And you have to, well, generally they have to specify, but you can specify what is being searched. Right? So let's say you have your car parked in front of your house. And they come up to you, you're returning walking your dog. Police officer comes up to you and says, points in the general direction of your house and your car and says, can I search? You think they're just pointing to your house. You have nothing in your house. You've got like heroin and shit in the back of your car, but you have nothing in your house. So you're like, yeah, go ahead. And then they search your vehicle. And you go, oh, I didn't think that's what you, we have to be specific, right? Can I search your house? Can I search your car? Right? If we're not specific, then we're probably running afoul of the law. We'd be taking account mental disability. So again, this is not only just mental health issues like anxiety and depression. Those obviously come into play, and we talked about that. This is also, in a legal terminology, I hate it. I wish legal terminology would change. But in the law, we still use the term mental retardation. Right? It's a legal term. So if somebody we believe is mentally retarded, again, from a legal standpoint, and I hate saying it, we're probably not going to get consent, right? We also call it mental disease and defect, right? We're probably not going to say that counts, right? If the person is mentally disabled and they have a support person there, that might change the analysis, right? The support person would have to explain to the person like what you're agreeing to, stuff like that. that changes a little bit. If it's somebody who's, we consider has a mental disease or defect and they're on their own, no, not going to happen. Also, we look at your experience with the criminal justice system, right? So we say, okay, looking at the totality of the circumstances, have you been arrested before? Do you know, like, you can say no? Do you know they're going to search your car if you say yes? If you have a record, like if you have at least a felony on your record, we're going to assume that you know you could say no, right? It's not necessarily like a legal presumption, but it's kind of like everybody in the room knows, yeah, he knows he could say no. Like, he's a felon. Like, he spent time. He should know. Same thing with lawyers. Lawyers never get away with it. Lawyers never get away with a consent search ever. Saying, oh, I didn't consent to it. Like, I was nervous. They're like, yeah, but you're a lawyer. You could say no. So they're shit out of luck. You're a felon, you're a lawyer, you're shit out of luck. You all, theoretically, somebody searches your possessions and finds drugs or whatever, theoretically, they could call me as a witness, and I could say, yes, I taught them a course in which I told them in any given situation, if a police officer asks, you should say no. You have the right to say no. So now you all are corrupted, right? Like, you guys are starting to fall down into here. If you're a criminal justice major, screw it, you're down there. Yeah, prosecutor really wanted to prove that you gave voluntary consent. All they have to do is call me. And theoretically, I could be called to the stand and say, yeah, I taught them, told them no. Like, you can say no. So, I just want to let you know that I've ruined that for you. So the totality of the circumstances doesn't necessarily apply to you because now you know. All right. Scope of a consent search. All right. So this is why this class is a two-parter, because like the regulations searches, they're short. It's designed to run over. So consent searches, the scope of it. It has to be objectively reasonable, right? So even if you say, yes, you can search my house, we have to say, objectively, what were they agreeing to, right? Like, what did they think they were consenting to? All right, so if you say, can I search your house? And you say yes, because you have drugs under in the walls, let's say, and they search your house, and then you see cops go in with sledgehammers. And they just start knocking down walls, looking for stuff. We're probably going to say you didn't consent to that, right? That's not objectively reasonable. Objectively reasonable is police officers come in, take a look around, maybe open a drawer here and there, look around, you know, that, okay, fine. But if they start knocking down walls, pulling up floorboards, we're probably going to say that's beyond what you consented to. So we have to be objectively reasonable. That being said, if you do agree to a consent search, if you take my advice and you throw it away, you make me sad, 1. 2, this could help you. But 3, you say yes, you, since it's a consent search, can tell the police where they can search, where they can't search, and you can revoke consent at any time. And they have to stop their search immediately. All right, so let's say you're just kind of like, wake up in the morning, can search your house, and you're just like, yeah, whatever, just do it. And they come in, they start searching, and you realize, fuck, I have a dime bag in my kitchen drawer. And they're coming, like, and you say, okay, hold it for a second. They have to stop. You say, you can search this cabinet, this cabinet, this cabinet, this drawer, not this drawer, this drawer, and this drawer. Now that seems suspicious as hell, right? Guess what? Police have to abide by that. So they cannot look in the drawer you said don't look in. And it can't necessarily be used against you as probable cause later to get a warrant, because you're just exercising your right. So theoretically, you can follow the police room to room and say, yes, no, no, yes, yes, no, no, like where all of your shit's hidden. You can tell them no. Yeah, it's suspicious as hell, but they can't open that drawer. Let's say you tell them no, and then they open the drawer, they find your evidence, your drugs. Guess what happens to those drugs? They get thrown out. It was a consent search, and you said you cannot look there. I'm not consenting to you looking in this drawer. And they looked anyway. They get thrown out. Also, you can withdraw your consent at any time. So let's say, like, you keep your drugs in the basement, right? Because it's a little darker and damper down there. It, helps preserve the quality and freshness. I don't know. Keep them in the basement, but you don't think police are going to search there. So they're searching upstairs, then they're searching your kitchen, on the ground floor, searching your living room, and one of them puts their hand on the door to go to the basement. All right, and they're still like cops up searching your room, stuff. You could say, I no longer consent to the search. And every single officer, no matter where they're at, has to stop dead in their tracks. So let's say they just cracked that drawer, they can't see anything, they can't pull it out. They have to leave it at the crack, right? You can withdraw it and they have to stop immediately. Same thing is true with your car, right? They want to search your car, and you say yes, you can tell them don't search the trunk. Don't search the glove compartment. Like, they're still going to search, but they're not going to look there because they can't, but they know what's going to be in there, right? But you're exercising your rights. It can't be used against you. So you can also withdraw your consent to search a car. Like, you remember that, oh, fuck, I have a kilo of heroin in the back. That's a lot of drugs, one. Two, you can go, no, I withdraw. No, you can't search anymore. No. And they have to stop dead in their tracks, right? Now, they can ask you, well, why won't you let us search? You don't have to answer them. It's your right. And if they ask you, and they start to kind of like pressure you, and then you give consent, we do that analysis again. Right, so we did consent the first time analysis. Right, then you said to stop. Then officers kind of kept pressuring you, like, well, what are you hiding? Why can't we search that drawer? What's in that drawer? Tell us what's in that drawer. What are you hiding? Finally said, just look. That's consent a second time. And we do the whole analysis a second time. We go, okay, police were badgering you. They asked you why you said no, why you exercised your constitutional right. They can fuck off. Like, that's what the court is going to say. They're like, no, no, that's not coming in. Right? You told them no. They started pressuring you. You told them yes. They found it. They wouldn't have found it if they had just listened to you. Game over. Right? And again, the idea behind the exclusionary rule and suppression is to protect your constitutional rights. It's to protect officers, or to make sure officers are doing their job in the correct legal manner, right? It's not to reward people, let them get off for crimes, right? The idea is officers put so much time, money, and effort into this case, right? The prosecutor did too. They build this case, and if it's based on a violation of your constitutional rights, and the judge suddenly says, nope, no drugs, can't be brought into evidence, and they have to dismiss the case, they've just wasted all that time, all that money, all that energy, because they violated your rights. And the idea is they're going to think next time before they do it, is this going to get it thrown out? Because I don't want to waste a lot of time, energy, money. They're going to think, right? It's going to cause enough like shock that you're going to be like, oh, fuck, they got away. All right, fine, next time we'll have a form, right? That's the thought process behind it. That being said, this also has to be clear and unambiguous. Right, so if you go to the kitchen and you say, I don't want you searching, no, I don't think I want you searching in that drawer. Like, I don't think so. I don't know, I just don't think so. You already gave me consent. Was that withdrawing consent? No, right? And some courts will say yes, but most courts are going to say no. right? I don't think I want you to look in that drawer is not, you cannot look in that drawer, right? There is a big difference between the two. You have to be very unequivocal where they can search, when they can search, what they can't search, and when they have to stop searching. It has to be very clear, right? Unequivocal can't be like a, I'm on the fence. It's a no or a yes, right? So that being said, we'll quickly talk about, do we have time? Yeah, we have 4 minutes. We'll start here next class as well to round out consent. Just, I'm gonna plant the seeds today. Third-party consent, right? So this comes up when somebody has what's called common authority over the premises to be searched. All right? So what does this mean? Let's say you and your roommate have common authority over your house, right? You're renting a house. The landlord also has some authority, but theoretically, it's just you two, right? You and your roommate, you split the rent, you're living there, whatever. You're gone away on vacation, right? And lo and behold, you get to, let's say, Aspen, you forget that you forgot your coat, right? Like you were gonna like have a grand old time in Aspen, but you forgot your coat. You left it in your room. And police just happen to come by and they're just randomly knocking on doors, asking if they can come in. They knock on your door and your roommate, let's say is a, I don't know, a science major, so he's a fucking idiot. And says, yeah, like, I have nothing, I'd come on in. But you're not there. What can happen? And that's where we'll start next class. All right, so that being said, have a good rest of your week, and I will see you on Monday where we left off.